All right, hi, welcome back. Attorney Steve Vondran. Welcome to another exciting episode of Litigation Whiteboard. Today we're talking about ex parte motions. If you're embroiled in a litigation, this could be state court, federal court, you may often find the other party is trying to file what's called an ex parte motion, or you may need to file an ex parte motion. Usually we have 30 days to file a motion. 30 plus days, you give notice to the other party. There's a briefing schedule. You file your motion, they file an opposition. You do the reply, the judge makes the ruling. But ex parte, these are known as emergency motions. So what are they? Without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, everybody. So happy Wednesday, February 19th, 2025. Today we're talking about ex parte motions. Now these are what's called emergency motions, okay? This is when you have something urgent, you have a deadline coming up, let's say you have a discovery cutoff, and you say, you know what, I don't have 30 days to file the motion and do the opposition and do the reply. I need an immediate ruling. There's going to be irreparable harm or irreparable damage if I don't get an order from the court now. And so you file what's called an ex parte motion. You can get it before the judge pretty quickly. You go ahead and find out what the court, check the court's website, see if they have certain days they hear ex parte motions. But let's take a look. These are what we call from one party. This is Latin. Ex parte is Latin for from one party, okay? So you file your motion. Like I said, typically you would have 30 days, but you don't have the time. Maybe you need a TRO real quick, or you need to alter the court's discovery orders and scheduling orders, things like that. Could be a lot of things, okay? Happens a lot in family law cases. So it's very simple. You're going to file an emergency motion, an application as it's often called. Check your local rules. This is general legal information only, not legal advice. You're going to file your emergency motion application. You're going to set forth your good cause. Good cause is you're showing the judge that there's irreparable harm if not immediately handled. If this does not get before the court real quick, something's going to happen, the witness is going to disappear, or something, could be anything, okay? So you need to make this affirmative showing to the court. Now, as I noted up here, these things are disfavored. They're disfavored because they're quick. You just dump it on the judge's desk and the judge's clerks and whatnot. So they're kind of disfavored, but there are times to bring them when it is legitimate. So do it wisely. Make sure there is an emergency, because the other side is going to certainly say, what's going on? There's no emergency here, Judge. They should just do a noticed motion. Give us 30 days. Let us do an opposition. We don't have time to prepare, so forth and so on. Anyway, you want to show your good cause in the application, irreparable harm, immediate danger. You also want to show that it's timely, that you brought this motion the earliest instance that you possibly could have brought the motion. You weren't just delaying, goofing around, that sort of thing. And you want to show that the exigency was not self-created. This is very important. You can't create your own problem and then ask the court to bail you out. That's usually not going to work. Judge is going to say, this is self-created. You can't get an ex parte order granted when you caused your own problem. That's another very important one. So pointed out why this was not self-created. Also, I have down here prejudice. Discuss why there is no prejudice to the party, or how you will be prejudiced, or both. So you're going to make a finding, a showing in your emergency application to the court. Over here I have, you may want to include a declaration as counsel, or even a declaration if you're a pro se party, showing that you tried to meet and confer with the other party, showing that you did provide the ample notice. Sometimes there is no time to provide notice. It's that big of an emergency, but you always want to try. There are due process issues if you're not giving the other party notice. So you always want to try to get that notice in as soon as you're aware that you're filing this motion. Meet and confer. Maybe seek a stipulation. Maybe the other party's like, hey, you know what? I'm totally fine with that. Why file a motion? We're good with that. So discuss how you met and confer. You provided the notice. State the good grounds for bringing the motion. These are all declarations, are just facts. You don't go into legal arguments. They're just facts. And then also discuss if you talk to the other party and they say, well, we're going to oppose, maybe just put met and conferred, the other party, seeks to oppose and will oppose. So just let the court know what's going on, explain why there's an emergency, explain all this, explain all that. Check the court's calendar, see the date that they hear these motions. Some courts you may need a reservation date. Check your local rules. It can't help you, can't do everything here. And then again, you're going to provide the notice that you can to the other party. You're going to try to meet and confer, pick up the phone, give them a call, give them a copy of the motion, let them review it, seek a stipulation. Maybe they'll just say, hey, fine, let's stipulate. And then ultimately you're going to file the papers, and you're either going to have a hearing by the judge or more likely a decision just issued. And the judge has wide latitude, wide discretion in granting or denying these motions. Don't forget your proposed order. You're going to need that. The judge wants to know, well, what do you want? What are you here in court for? What are you seeking? I'll tell you if I'm in or I'm out. So that's a kind of a basic overview of filing an ex parte motion. It's contrary to what we normally like to file in federal court, state court cases. Litigation is a noticed motion where you're given 30 days plus and you go through the briefing schedule. I have a video on that if you want to watch it. So anyway, I hope this is helpful. General legal information only, not legal advice. Have a great day, everybody. Feel free to share this video on your social media networks. Attorney Steve, the first name in legal services. You know where to find me on the web at attorneysteve.com. Have a great day. Thanks for watching, everybody. I got to run.